For joining me. Today I'm going to go over a last segment in Emerson Bar Review and expand on it. So I put the timestamp here in the actual video, and we're still on our day 1, hour 2 of Emerson's Gold Standard Bar Exam Repeaters videos that he donated to the public, and he's a brilliant man. So, without further ado, what I'm going to tell you is that I found the actual essay, Owens versus Carter, but I haven't found the other one yet. And I have a lot of material that I can go through and resources to try to find the other ones. It's just having the time, right? And a lot of this with studying for exams is setting aside the time and doing the exercises, because we learn through the exercises. And sometimes it's painful and hard to focus when other things are going on in your life, but it's like doing a workout, no pain, no gain, right? You have to follow the plan, and sometimes stuff gets in the way. You sprain your ankle, you can't jog for a while. Just do the best you can, right? So, this book is also this essay is identified in Fleming's Fundamentals of Law, Baby Bar Home Study Packet, Volume 2 from 2013. And it's written at the top as Essay February 2001 question. It does not have the answer. It asks, in his thing, he asks you to do a practice essay, and he doesn't tell you. He goes through a whole bunch in his package on how to. He goes through everything in a pretty expanded detail on an outline for studying contracts, but then afterwards he tells you to do practice. So anyway, so back to the Emerson Bar Review. At 4930 is about where it starts. I'll put this link below so if you want to jump to what he says. Now I will tell you what he says briefly in a minute, but I want to emphasize the fact that if you're studying for the California Bar or just law essays or the baby bar, it's important to put the time in and try to focus. And I noticed, I reviewed the video that I did and the question that I answered, and when you analyze these old multiple choice essay questions, the model answers are not consistent, and that can be frustrating because people are very varied in their opinions and what they're going to pick up and what they're going to discern and decide to write about. And the examiners are going to be a little bit more subjective than they would in an objective multiple choice test. But if you go through all these multiple choice and old essay exams, you're going to start noticing that there's overlap, and they actually flip around. What do I mean by that? I mean that you will see a question on the essay that is in the multiple choice, and vice versa. You will see an essay question that maybe has an essay pattern that has 3 questions that you have to write out, and then, lo and behold, you will see it popping up maybe with different names, slightly different dates, exact same pattern. Well, how many combinations and permutations are there of problems that arise in life? Well, as the law goes along, they get new problems and new things happening, and they make new laws and new rules on how to solve the problems. So in a way, it's kind of like problem solving for math, right? You memorize the formulas, and then you do the practice questions, and the way that you learn is by doing the practice questions. So look at the 6 general patterns that Emerson gave in the first video, and these are the categories or outlines that typically pretty much fall on most of the contract's questions, and he tells you what to look out for. Most of them have formation issues, or questions. And so you have to get these ideas and cross-reference if you can. Now, I just wrote this um, sort of talking points, but I'm not going to go totally on script. But I gathered my thoughts before I went in here. Now, if you're writing an essay, remember the IRAC method. This method I first learned about as a paralegal when I was taking an ABA, a paralegal writing class. Then later on, I moved on to go to graduate school and I got a master's. Lo and behold, it's showing up. Then I got in a JD. Same thing. But I will tell you one thing. There's two main legal writing methods in America, and they're the American law method. This is for professional responsibility probably, but from jurisdiction to jurisdiction it's going to change. But this whole idea about issue, rule, analysis, conclusion, break apart, show your reasoning. This is like a math teacher saying, I don't want you using a calculator. I want you to break it apart and show me you know how to do this. So, and also maybe something doesn't make sense, and then you show the steps how you got there to your conclusion. You can't just write your conclusion. Now, this is for essays. Now, if you do the multiple choice, you can go straight to the conclusion, right? But with the essays, this is where you can really show off your memorization, writing, and legal skills. Oh yeah, and the Juris Doctorate, I took a writing or some kind of introductory class, and there it was, IRAC. So I snipped a few things from the last video, and I reviewed the video again. And when I reviewed it, more things popped out at me. And the second time around, I put the some of these videos I was able to get them to put the captions. YouTube, when you upload a video, you can get them to put captions in, but they're AI generated, and the AI sometimes mixes up the words based on the way it perceives the enunciation of the verbiage. So the basic thing here is that he is telling you how to write the essays, and he is breaking down the parts of the law, and he's showing you a template or pattern for the writing or the outline. And I said, I have an outline. My outline's different. Well, my outline is not just for writing essays. It's also for rule memorization or review to keep it fresh in my mind. So there's going to be a slightly different approach between the different laws, and there's going to be slightly different approach between the multiple choice answering and the essay answer. But the big takeaway from this is that practicing the multiple choice, when you get it wrong or right, you look up why it's right or wrong. And that's why I like the BarMax, because the BarMax has like a little window in it, and it has, you can ask questions, and it has lifetime support for the multiple choice. And you can say, well, I thought this rule applied, and you can actually get support for that, and they highlight why the answer's wrong or right. So anyway, with the Merchants UCC 2104, which is what Emerson mentioned when he was going through this, the second time around, I didn't even notice that the first time, and some of these things, so he was saying it was Merchants, so I went and did a quick Google, and I found Westlaw, and then I took a screenshot, and here's the URL where you can find it, but it was the first thing that came up in the search this afternoon. And what it said was, it defines a merchant as a person who deals in goods of the kind or otherwise by his occupation holds himself out as having knowledge or skill peculiar to the practices or goods involved in the transaction, or to whom such knowledge or skill may be attributed by his employment or an agent, broker, or other intermediary who is by his occupation holds himself out as having such knowledge or skill. Now you can just Google this too and find it. But I thought it was interesting because Article 2 has special rules for merchants, including but not limited to 2103B, good faith, 22012, statute of frauds between merchants. Now, this is the issue that Emerson brought up in this last fact pattern that we talked about, and that I read off the essay and put beneath. So this would be in the one before this. And so this one is going to focus on reviewing a little bit of snippets from the UCC and then going on to this common law Owens problem. And I just introduced where I found that. So sometimes when you hear it a second or third time, more stuff jumps out at you because this is highly condensed information in 1 hour, and it's a lot to absorb at once. So then I snipped this other thing. Under the UCC, all you need is good faith. Now, what did that thing say that we just reviewed from Westlaw? It said the same thing. And I don't know, Emerson's got the best memory around. He's like, got these all memorized. Well, if he took the bar, he'd be able to put the exact rules down and everything. So, but to pass, I'm going to show you, I found actually a passing, okay, another thing I noticed the second time around is that he changed around the agenda, and he had a hypothetical in his hand, Bar problem, so he goes ahead and he improvises. He thinks it's another UCC because the way he had it set up, he was going to do 2 UCCs and then 2 common laws, but then he's got the common law one in his hand, and then he thinks it's another UCC because the way he had the plan was to do 2 UCCs and then 2 common laws. So I think when I go over to 3, maybe these other ones, but actually he's got the Owens-Carter in the end, but he's got the Bar here. So I'm assuming maybe next time he'll do the Solar turbine. We'll see. Okay, so the last one we did was the Motors versus Jones. You can watch it as many times as you want. Now, when you're reading these essay answers by other students or other people, the ones that the California Bar uses are the ones that I'm just scrolling back up to the start. The ones that they use are the people that are taking the bar's answers. Okay, so they're not going to be perfect, but they're going to be used as an example of what is a good example of a passing bar answer. So if you want to, here's what you can do. You can review Emerson starting at 4930, and he's going to go over this question. I'm going to read you off the question. I have it in a separate document here, and it is, I'm going to read you the question, and then I'm going to read you the model answers the California Bar gave, which, now remember when you're watching these, if something doesn't make sense or you want to cross-reference, that's what you do. You go ahead and cross-reference. But you know that these are passing answers. Okay? Now, do you need to memorize what UCC has and write word for word what they have in that Westlaw snippet that I gave you? No, you don't have to do that. And I mean, you could, if you've got a photographic memory, but this is awful long. Can you can you write this really fast? This is 1, 2, 3, 4, 5 and a third, maybe a quarter of a answer, maybe. And then you would write your analysis. You don't want to waste a lot of time, so maybe you could paraphrase it and condense it, right? So right here's the good faith, the statute of frauds. So actually, when I spoke last time doing the analysis of the Motors versus Jones, or yeah, that was it. So I did not pick up on the fact that I had watched the the section on that, and then I went and did some research, and then I did a practice exam off the top of my head. I couldn't remember the exact rules, and then I showed you what I got because I couldn't find the model answer, and he's explaining how you should answer it, but it's some of it's subtle because actually next time around I guess he was considering them to be merchants, and I was right, but he was saying it in sort of a subtle way, and he was naming off the rules. So, and I took notes on it, but I mean, you watch it a couple of times, and each time you watch it, you learn more. So let's look. Here's how we get real life hypothetical problems that may or may be mirroring real life, like art imitating life, and then the different responses that are passing answers. So you can watch Emerson on that, and I'm going to go ahead and read this off, and then one of the answers. You don't have to watch it all the way through or all at once. You can do it in chunks. You can speed it up. You can slow it down. There's a little wheel on the YouTube videos, which I really like. It's a nice feature. You can make it go faster or slower. And also, I set it up so that it will put in subtitles if you want. You can listen while you're multitasking or doing something else, but don't look at it if you're driving or doing something that requires your undivided attention. Okay, so let's go with this one. This came from the 2001 California Bar Exam, and it's about Owens, a homeowner, who approached Carter, who's a licensed contractor, to discuss construction of a new garage attached to Owens' home. After several meetings, Owens and Carter signed the following contract. Carter will build a 2-car garage with overall dimensions of 30 width by 25 depth. Including within the overall dimensions will be a storage area at the rear. The storage area to be 30 by 4 and divided from the remainder of the garage by a wall containing a door. Wooden siding, paint, and roof will be matched to Owens' home. Carter will commence work on March 15th and will complete the job no later than April 30th. Owens agrees to pay $8,500 upon completion. The time for performance of these obligations shall be of essence. So, that's a term of art, if you will, time of essence. Oh, by the way, I have a real estate license, and we discussed contracts with that. So anyway, let's get back to the fact pattern. Okay, so the contract was signed on January 15th, and Carter arrived on the job site on March 15th to begin the work. Several weeks later, Carter learned that roofing shingles of the exact type and color used on Owens' home were difficult to obtain. Therefore, he used shingles made of other material, which were of even higher quality than those originally planned, but which, although very close, did not precisely match those on the roof of Owens' home. Carter completed the garage on May 10th and presented Owens with the bill in the amount of $8,500. Later on the same evening, Owens placed his car in the garage only to learn that the length of his car did not permit the garage door to close. Upon closer inspection, he discovered that the storeroom at the back of the garage was 30 by 6, 2 feet deeper than planned. As a result, the garage parking area was only 19 inches in depth. Excuse me, I have to take a sip of a beverage here. My throat is itching. Okay, while this would be sufficient for most automobiles, It was several inches too short to accommodate Owens's large car. Oh my goodness. The cost of removing and relocating and dividing the wall would be $800. The cost of removing and replacing the shingles with other matching Owens' home would cost $2,200. Owens refused to pay any part of Carter's bill, citing as reasons Carter's failure to complete the job by April 30th, using matching shingles, and to build a garage and storeroom in the dimensions called for by the contract. What are Carter's rights and liabilities? Discuss. So, this is asking what are the contractor's rights and liabilities? Okay? Not what remedies Owens has, but what are Carter's rights and liabilities? Always answer the call of the question, right? So let's see what these winning answers are that pass the bar and are model answers to the bar. Okay, the first question, answer A, is Carter's liabilities and rights under the contract. No period at the end. Carter's contract with Owens complied with all the formation requirements because it has mutual assent, consideration, and it was in writing, satisfying the statute of frauds. So the issue here involves the performance of such a contract by Carter. Excuse me, if Carter's contract with Owens had conditions, then Carter's compliance with those conditions will be at issues. Whether Carter's performance is excused is also determinative of his rights and liabilities. Finally, if Carter's performance duty is not excused, then whether his performance was a breach is sick. Now, the California Bar put that in there because there's a few typographical errors in there, and they want you to know that they're aware of that. Okay, so then this is divided by this examinee as time of essence clause on contract. So let's go look back at the question. They ask three sections, right? And the first one is being labeled by them as A, complete the job by April 30th. That is the time of essence, right? Okay, the contract had a time of essence clause at the end. Courts will construe these clauses strictly if they are intended by the contracting parties. Since it was expressly stated, the courts will not second guess the intents of the parties and strictly construe this clause. Since the clause will be strictly construed by the courts, then this clause will be viewed as a condition precedent to payment. Precedent precedent. Potato, potato. Okay, you get it? That's the way I pronounce it. If the party can fully perform by the prescribed dates, then the condition precedent to the payment hasn't been satisfied. Now, the AI might write this down and interpret it differently than what I'm saying. So when you're looking at the subtitles, if you turn them on, it's spelled Precedent, precedent. Now, it sounds a little like president, but that's spelled differently, obviously. And you could say precedent, like it precedes. But I pronounce it that way. I could try pronouncing it differently, but anyway, so just to clarify. Okay, so as such, Owens need not pay Carter the $8,500 because the express condition of completing the construction by April 30th wasn't complied with. So, Owens has a right to withhold payment because the condition wasn't satisfied as stated by the contract. Now, if you're looking at the fact pattern, you will notice that my grammar check is on. And it's underlining in blue some things that might need a comma or aren't spelled correctly, etc. Okay, just ignore it. I'm just going to keep going. But to render the whole contract breach just because the time of the essence clause wasn't fully complied with will be too harsh on the breacher. Carter did tender substantial, if not full, performance by building the garage and the storage room. The issues with the shingles in the storeroom will be discussed separately in the next sections. So the court may not strictly construe the time of essence clause as an express condition. Instead, if the court construes the condition as a covenant instead. So here's some important key points that he's putting in here. He's using the proper legal verbiage. Covenants are promises, okay? And the, uh, the conditions are another term that you're looking in contract law. So I'm just going to kind of pop those out for you. And you can actually look those up. And Emerson has a separate video on that, which we may or may not get to, I don't know. But it's in the playlist of the 13 Emerson Bar contracts videos. And it's also in the 2007 complete bar playlist, which I don't have organized that well, but I downloaded the videos and put them up. So, okay. Then, Carter's failure to finish by April 30th will not be fatal. Well, isn't that dramatic? Okay. I'm just, making comments from the peanut gallery here, but hey. Covenants are promises by the parties that they'll abide by them. Now, I'll tell you right now, if you are a PhD student, one of the things they tell you in APA is these contractions, they'll, are forbidden. You're supposed to write they will, just to let you know. But that's okay. This is a passing answer. And they'll abide by them, and failure to do so will result in damages to the aggrieved party. I'll put this cursor underneath so you can see where I'm at. If the time of the essence clause is not an express condition, there he goes again with the express condition, precedent, I'm trying to make it sound precedent to payment, then Owen's obligations to payment is not excused. Okay. He will only be able to claim dollar damages because Carter didn't comply with the covenant of time of essence clause. Now, B, matching shingles. Now, let's see if that's the exact pattern. Yes, it is. 2 is B, ABC. He's doing ABC instead of 1, 2, 3. Okay. The express terms of the contract have to be complied with by parties because that reflects the party's intent and their duties under the contract. Now, this is another thing you look at in contractual obligations. You look at intent. It's part of the willingness to manifest into the agreement and meeting of the minds. Okay, so where am I? Since the contract expressly stated that the shingles will be matched to Owen's home, failure to do so will be a breach. The issue is whether the breach is a material one or a minor one. Now remember in the last one, we talked about material breach in the Motors Jones, and I said it was a material one. Now, this is talking about material too, because when you're looking at the law, you're looking at different ways of weighing the concepts and the degree of the grievance. It's kind of like in medical stuff, they'll ask you, they'll stage things. So they'll say from 1 to 4, 1 to 10, what's your pain? If it's more than 6, that's, one's severe, one's moderate, one's, so basically it's the spectrum. And this is the two ends, material, minor. And here he's going to explain it. He says, in a minor breach, the aggrieved party is not excused from full performance of her duties. So Owens should still pay the contract price to Carter minus the cost of the minor breach if matching shingles is indeed considered minor. Okay. But if the failure to put matching shingles onto Owens' garage is a material breach, then the aggrieved party is excused from payment. Okay? So he's talking about both ends of the spectrum here and what the different answers would be depending on that. I actually hit the theme colors instead of the highlighters. Okay, so the matching of the shingles to the house is probably a minor breach. Okay, so this is what the interpretation is by the examinee. He said it's a minor breach. I have to agree. Whether shingles match or not exactly doesn't affect the construction of the garage and the storeroom. This only goes to an aesthetic issue, okay? So, you're thinking of how it appears and the utility of it, and also the different, access to the exact, so it's also subjective. Now, remember I was saying that when they grade these, it's a subjective grade. Wait, here's the highlighter. Hold on. So, what is subjective? It means it's subject to interpretation. That's how I say it. It's you say potato, I say potato, potato, tomato, tomato. Let's call the whole thing off. I think that's a song. But anyway, subjective, whether Owens thinks the shingles match with the house or not. So the failure to match is not a material breach, since a substantial part of the contract was not to put shingles on, but rather to build a garage and a room. Now, as a real estate agent, and maybe I'm not an appraiser, but if you're trying to put the house up for sale and you're doing a renovation and it's off a little bit too much, that curb appeal might be kind of gone. So I don't know. It's arguable, but I do think it's kind of minor. And actually, he got better shingles, higher quality shingles. And, depending on where the sun's hitting the shingles or if you've got a tree nearby, these things fade over the years and they weather. So anyway, Carter may even argue that the shingles matched and so there wasn't even a minor breach. But Owens will counter by saying the contract expressly asks that they match his home, and since they don't precisely match, there's a breach. Okay, some people are really picky and perfectionists, and they want it a certain way, Albeit the discrepancy may be minor, but the courts again will construe the contract as the intent of the contracting parties. So, it's one of those things about, and I think Emerson put it this way. He put it about, if you look at the law, there's like these theories and these customs and these traditions, and sometimes the customs of the law or the practice in the area is not the same standard as you personally have. So it's not what you subjectively believe, but if you look across the board at what the custom is in the trade of the profession, or what did he call it? He said the trade something or another. I forget. If you watch it, it's only like 10 or 15 minutes of the last section, so you can hear what he has to say. Another way to get around the problem of not getting precisely matching shingles and so having breached in a minor way would be the concept of excuse. Carter, this is all, the construction contractor's defenses or what his right, the call, the question we just read it. Carter may assert he's been excused by impracticability because the perfect shingles weren't obtainable with ease. In other words, it was like frustrating for him to find them. He couldn't find them, and he even got higher quality ones that more closely matched. But for impracticability to be a viable excuse, the burden must be so severe for compliance to render the compliance impracticable. Here, the burden to look harder for those matching shingles can't be severe. Although Carter did use better quality shingles, Owens contracted for matching not high quality shingles. So Carter's assertion of impracticability to excuse his duty to get matching shingles can't prevail. So now he could even argue, now I don't know, because time was of essence and procuring the exact shingles might take longer and have to extend the contract out. He's already running late. You can see he didn't complete it quite on time. But Carter can assert that he's mitigated by using almost matching shingles. Remedies section will discuss the mitigation. Okay, C. Building of the garage and storeroom as specified. Once again, the contract expressly stated the duties and term for Carter to perform and abide by. So Carter's failure to comply will be a breach. Okay, so here we are on breach. These breaches have a stronger argument to be material ones because the contract's essence is to build a garage and a storeroom in a specified dimension. Since the contract expressly required Carter to build them in a certain size, the intent of Owens was clear. So Carter's failure to perform as instructed will be a material breach. Yes, indeed, agreed. So here we go. Because the dimensions of the garage and the storeroom didn't follow the contract as stated. Okay, as such, Owen can be excused from performing because it's a material breach. However, if it's a minor breach, then the court will still require Owen to pay Carter. The failure to comply with the exact dimensions could be viewed as a minor breach because the garage and storeroom were completely built as directed with design materials and overall dimensions roughly. The deviation from the dimensions are only 2 inches, so the breach could be minor. Still, normal cars would fit. The purpose of the contract is not frustrated because Carter still built a garage usable by cars. It's just that Owens has peculiarly long cars that don't fit without an extra 2 inches. However, Owens didn't communicate this to Carter, so Carter's failure to take heed in ensuring the dimensions are at least 30 by 4 and 30 by 25 couldn't be Carter's fault. Therefore, Carter's failure to follow precise directions could possibly be viewed as a minor breach. Then he'll still be entitled to the contract price minus the costs of fixing the breach. So here's where, lawyers come in and they get in and they argue for their client, right? Okay, so breacher's remedies. Okay, so material breach. If the court construes the aforementioned breaches as material breaches, then Owens is permitted to withhold payment. Owens can also get the cost of completing the garage and the storeroom and the replacement of the shingles from Carter. Those are his expected damages, and Carter will be liable for them. Okay, so expected damages, and Carter will be liable. In other words, here the contractor did all the work, he didn't do it quite right, and now he's on the hook. Ay, 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 ay. Okay, so let's go to the next one. However, under restitution, it will be unfair for Owens to get the entire garage and storeroom without paying Carter anything. So restitution allows Carter to get back the benefit conferred onto Owen, so that an unjust enrichment of Owen wouldn't result. Now, here's some of the key words: unjust enrichment. These are contract theory. These are contract words. Restitution, benefit conferred. These are key words, key terms that you're looking for. Okay. So just to let you know, these are in the books. When you're reading the cases, and these are the theories and the rules, kind of the analysis that you want to plug in there. This is a good answer. Okay, so Owen should disgorge the cost of the garage and the storeroom minus any costs he'll incur for fixing the material breaches. Since the contract was for $8,500 and Owen's cost of remedying the wall and the shingles cost $3,000. So here you are. It cost $3,000 for Owen to fix what Carter did wrong or not to specifications. Then Carter can get $5,500 back on his restitution costs. In other words, minus the damages. So, it's just you go to court and everybody wants some kind of big remedy, and so it's costing a lot in attorney fees, and you've got all this stuff going on. Okay, minor breach. If those breaches are minor, Owen should pay the $8,500 to Carter, since he did substantially perform and his breaches weren't willful. A breacher can still collect the contract price because he substantially performed. Now that's the idea of substantial performance. Okay. And however, Carter must pay Owen the cost of remedying the shingles and the wall removal. Excuse me. However, Carter must pay Owen the cost of remedying the shingles and removal. The car will fit. So the car will fit. But Carter will argue that he need not pay $2,200 to Owens because he substantially complied by providing better quality and closely matching shingles. Carter mitigated by using closely matching shingles. So Owen needs to mitigate the damages from these non-matching shingles by not replacing them entirely. Carter should not be liable for the $2,200 for replacing the shingles. Specific performance. Generally, courts are reluctant to grant specific performances because personal services contracts are hard to administer, and it will be imposing involuntary. He put solitude, and really, this is a typo. This should, I'll tell you right now, this should say servitude, okay? Let me write this in just in case. Servitude. Okay, so this is a passing answer. I'm going to put a red on here. Just a note so that I know I corrected this if I go back over this again. So a lot of times these model answers, so if Owens asked for specific performance by Carter to redo the garage and the replacement of the shingles, such a remedy will not be granted. Most important reason is that there is an adequate legal remedy in making Owens whole. So specific performance will not be something Carter needs to do for his breaches. Okay, so the court can't make him correct what he did wrong, or not to the satisfaction of his what he contracted to do. Now, we can go ahead and look at question B, answer B. What do you notice about this and the other ones we've been doing? The answers aren't perfect. The definitions aren't perfect. This is pretty darn good, and it's one of the ones that they're putting up as an exemplary answer. Okay? This is what they like to see. or close enough. Okay? People are human. Okay, so let's go to answer B and see how they put this. Okay, they want to write O and C. I can't stand it when people do this, but that's me personally. But I think they're doing it to be able to fit more in. They'll put P for plaintiff and so on and so forth. Now with APA, well, you know I'm working on a PhD and I'm following the APA, but sometimes I get hung up on things like that and nitpick. But on the other hand, I'm realistic, so I understand sometimes I put abbreviations, but anyway, so Owens O and Carter C entered into a valid construction contract to which the common law of contracts applies. So here, they're letting you know this right off the bat in the formation that we're using the predominant, well, I don't know, it's not really a predominant factor test, but we know even though they're going to use a whole bunch of materials, that the guy's not buying materials, he's buying the service and the construction. It's a service contract, it's common law, right? The determination of C's rights and liabilities depends upon the analysis of his performance of the terms of the contracts and any breach thereof. Very nicely put. At common law, the duty to perform may be discharged by exact performance of the terms of the contracts. A performance which does not conform to the terms of the contracts does not discharge the duty and is a breach of the contract. A breach may be either minor or material. A material breach is one that so substantially affects the value of the contract or the benefit of the bargain that the duty to pay the contract price is discharged, while a minor breach occurs when substantial performance has been rendered. In the event of a material breach, the breaching party may not recover under the contract, but may recover any benefit bestowed under quasi-contract. Now, this is a very important point. The other person did not bring up, and actually, I believe Emerson brought this up a couple of times. Okay? Quantum merit principles, quasi-contract. In other words, you didn't have a contract for this part, but you still have a contract. Okay? For minor breaches, I don't know if that's, well, anyway, so the minor breaches, the breaching party may receive the contract price less the amount by which the defective performance reduced the bargain for benefit. Again, key words. They're plugging in key words. It's not being broken apart. You're getting a summary at the top. It's a little different. So breach, time of his essence clause. Now, do you see how he's using the number one, not a, or she. Okay, so a time of the essence clause serves to notify the parties that a failure to render performance by the specified date is a breach of contractual term and may entitle the promisee to damages. Okay, you got the promisee and the promisor. And I think that the word check in here, the spell check, doesn't have a very large data bank of words and it doesn't understand that's a real word. Okay, so that's not wrong. Okay, now this is just kind of like a grammar check thing here. Here C breached the time of the essence clause because he finished performance 10 days late. There is no showing that this caused any actual damages, and so O's remedy would be limited to nominal damages. That's money damages. So Carter's liability for his minor breach is negligible. Failure to use matching shingles. 2. C has an argument that he did not breach the relevant term at all. It's unclear from the contract whether the term matched means A, the siding paint and roof on the garage shall be constructed from precisely the same materials as corresponding pieces on the house. Or B, the siding, paint, and roof shall be of reasonably similar materials so that the totality of the house and the garage match to a reasonable person or even owes satisfaction. If customarily in construction contracts it means the latter, C will prevail. In the absence of contrary evidence of the parties' intentions, O could have, but did not specifically, excuse me, bargain for exactly matching shingles. It might have been wise to ask to or notify O about the non-match earlier, though. Okay, so communications are important. Assuming that C loses the above argument on the interpretation, he has failed to perform exactly and thus breached. The breach does not go to the value of the bargain for consideration. The roof is otherwise a perfectly good roof, and it may be superior to the one bargained for. Look at this. They've got a little an emphasis here. O will not be able to obtain the cost of removal and replacement, but will only recover the difference in value, if any. Again, C may be liable only for nominal damages. Now, notice they said may be. Okay, so that's important because it's kind of arguable. But the preponderance of the evidence of whether it's material or minor breach, is a little arguable. So failure to build the dividing wall. C's failure to put the wall in the right place is a more serious issue because that failure does go to the suitability of the garage for O's intended use. Let me fix this. To the value of the bargain for benefit. However, the cost of correcting the problem is less than 10% of the total contract price. This is likely to be considered a minor breach with damages of $800. C may file suit against O for $7,800, the contract price of $8,500 less the $800 to relocate the dividing wall. Unfortunately, the time of essence clause has the effect of cutting off the time of performance allotted to C. So C cannot correct his mistake and sue for the entire contract price. And so that is the end of the second model answer. Now, you've got to realize that when you're taking these exams, you have to go from memory. You've got an hour to get your facts straight and write them down. And some people spend 15-20 minutes outlining before they do that on a scratch paper. I don't know what the exam conditions are going to be for the February bar, but I believe they're in person. This year, I don't know for sure, but I know that they're still giving the first year students exam in a couple of weeks online using a new proctor contract. I don't know. So anyway, that is the long and short of it today. And next time, I hope I have time to get over to the other, but I do have other obligations. I want to thank you for your comments, likes, shares, subscribes, and have a great rest of your day. Bye.